Hello, welcome one and all. My name is Travis. I am an attorney based in California, and I've been practicing law for about 10 years. In this video, I want to talk about how lawsuits work, specifically what happens during a lawsuit from beginning to end. So by the end of this video, you should have a pretty good sense of what to expect if you ever find yourself in a lawsuit. The information I'm about to provide will apply to both state and federal civil litigation. So one question I get asked a lot is, how long does a lawsuit last? And the length of a lawsuit is, generally speaking, a function of a few factors. Chief among them are the complexity of the facts in the case, how busy the court is, and how much of a backlog of cases there are, and then lastly, the parties' willingness to settle. If the parties can work out a solution to everybody's satisfaction fairly quickly, then the lawsuit can wrap up in a matter of months. So generally speaking, if a lawsuit ends in a settlement, then the minimum length is about a year. If the lawsuit proceeds all the way to trial, then the minimum length is at least 2 years. So in a lawsuit, you have two sides, the plaintiff and the defendant. The plaintiff is the party who brings the lawsuit. The defendant is the party who is the target of the lawsuit. A lawsuit comprises of 4 main stages. 1, pleading, 2, discovery, 3, trial, and 4, collection. In the pleading stage, the plaintiff fires the opening shot by filing the complaint with the trial court. The trial court is the lowest court in either the state or the federal system. In federal court, the trial court is known as the district court. In state court, there are many names. In California, the trial court is known as the superior court. In Illinois, the trial court is the circuit court. And in the great state of New York, the trial court is confusingly called the Supreme Court. So the plaintiff goes to the trial court and files what is known as a complaint. So in the complaint, the plaintiff discloses who he is, who the defendant is, what the relevant facts are, and also the claims that he is bringing. These are also known as causes of action. Some examples are breach of contract, negligence, trademark infringement. After the filing of the complaint, the plaintiff has 60 to 90 days, depending which court he is in, to serve the complaint upon the defendant. So after the defendant is served with the complaint and summons, the defendant has 21 to 30 days to answer the complaint, or to move to dismiss the complaint, otherwise known as a demur. What if the defendant does not respond to the complaint within the allotted time? Well, that allows the plaintiff to request the court to enter a default judgment, which means the court will take everything in the complaint at face value and award to the plaintiff whatever the plaintiff seeks in the prayer section of the complaint. So, the defendant must avoid default at all costs. In the answer, the defendant has to either admit or deny every allegation in the complaint. The defendant can also assert affirmative defense, counterclaim against the plaintiff, or cross-claim against co-defendants if there's more than one defendant. So the discovery phase is really the bulk of the lawsuit. So the main purpose of the discovery stage is to exchange evidence between the parties. And there are many ways to obtain evidence. You can obtain it via interrogatories or requests for production, requests for admission. You can take depositions, or you can subpoena evidence from non-parties. So most cases, about 95% of them, settle during discovery. And one way to settle a case is mediation. That's where you have a third-party mediator, usually a retired judge or an experienced attorney, tries to get the two sides to meet in the middle. Sometimes mediation works, sometimes it doesn't. And if it doesn't, then we move to the next phase of litigation called trial. So trial is what comes to mind when most people think about lawsuits. A trial usually takes a few days to a few weeks. The first thing to happen during a trial is jury selection. And most states, as well as the federal court, will settle on 12 jurors. After jury selection, the two parties, the two sides, they make their opening statements to the jury. After that, the plaintiff presents his case, which is to say the plaintiff will present evidence, will call witnesses to the stand or expert witnesses, and then the other side will have a chance to cross-examine those witnesses. After the plaintiff rests, the defendant will get a chance to present his case and also call his witnesses and experts. And then we have the two sides make their closing arguments. Now this is the last opportunity for the two sides to make a positive impression on the jury. After that, the jury retires to the deliberation room to hopefully reach a verdict. In a federal trial and state criminal trials, most of the time, the jury needs to reach a unanimous decision. However, that may not be true in civil trials. For instance, in California, in a civil trial, only 3/4 of the jurors need to agree before reaching a verdict. Now that is the end of the trial court portion of the lawsuit. The losing side now has an option to appeal the decision. If there is no appeal, then the judge enters the judgment pursuant to the verdict. The prevailing party is known as the judgment creditor. The losing party is known as the judgment debtor. After a judgment is entered and then noticed, the judgment debtor has 30 days to pay the judgment creditor. So let's move to the next and last phase of a lawsuit, that is collection. So the good news is you've won the lawsuit. The bad news is you still have to collect the judgment. So this comes as a surprise to most people. So you might be thinking, wait a minute, did I hear you correctly? I have lived through this lawsuit every day for the last for the last however many years, I have experienced extreme agony, plumbed the depth of misery, and spent half of my life savings in attorney's fees. And now that I have finally prevailed, you're telling me that I have to pay more and wait longer? Yes, I'm sorry to be the bearer of bad news. So, the court is not responsible for collecting your judgment. You are. Now, if the judgment debtor pays the judgment creditor in full within the 30 days after judgment is entered, then there's no problem. Done and dusted, everyone goes home. But if the judgment debtor fails to pay within 30 days, the judgment creditor is not without options. And there are several. One, which is also the least expensive, but also the least likely to get paid. And that is, the judgment creditor obtains an abstract of judgment from the clerk of court, and then record that abstract of judgment with the county recorder's office. This creates a lien against every real property the judgment debtor owns in the county. And you can do this for other counties where the judgment debtor has real property. So when do you get paid? Well, every time the judgment debtor sells a real property or refinances a real property, you would get paid from the escrow. However, it is possible that during the effective period of the lien, which is 10 years in California, with the possibility of renewal for another 10 years, it is possible during that period the judgment debtor does not sell or refinance any of his real properties, in which case you are out of luck. So it's not an ideal situation. Well, here's another option for you. You can request the court to issue a writ of execution, which will enable the sheriff or U.S. Marshal, in the case of a federal lawsuit, to levy the judgment debtor's assets on your behalf. So that includes garnishing the judgment debtor's wages, attaching his bank account, levying or seizing the judgment debtor's vehicles, boats, force the foreclosure of the judgment debtor's real properties. If the judgment debtor has a physical business, you can even request the sheriff to go there and seize all the cash in the cash register. Okay, so I know what you're thinking. What if I don't know where those assets are, or even what assets the judgment debtor has? Well, there's a way to find that out, and that is through the judgment debtor examination. That is, you haul the judgment debtor into court and then examine him under oath about all of his assets, and you can go into excruciating detail about what they are, where they are. What can the judgment debtor do if he wants to contest the judgment creditor's writ of execution? Well, the judgment debtor can file what's known as a claim of exemption. Exempt properties are properties that are exempt from collection. They are usually assets related to one's basic needs, such as Social Security benefits, disability benefits, unemployment benefits, tools of a trade, clothing, household goods, so on and so forth. All right, so let's talk about the worst case scenario. If the judgment debtor is insolvent, which means the judgment debtor has only exempt assets, then more or less you're out of luck. Okay, you can only hope the judgment debtor comes into some kind of an inheritance. Other than that, the judgment debtor is what is known as judgment proof. So this is why it is very important at the outset of a lawsuit to conduct an asset search for all of the defendants and make sure that in the event you prevail in a lawsuit, you actually have a chance at collecting on the judgment. So as you can tell, litigation is a complex web of moving parts, which can get very confusing very quickly. So it's essential that you have a zealous and competent legal advocate by your side, guiding you through every step of the lawsuit. All right, so that is a lot of information to absorb. I hope you have learned something and found this video helpful. If you did, please give me a thumbs up. And if this is your first time here, consider subscribing, because I have a lot of information coming your way regarding all aspects of the wonderful world of law. So until next time, goodbye.